In this video, we will discuss veto power of the president and the Indian federal system. This is the part 3 of the video, and the discussion is based on Spectrum's Indian polity. Though the Indian federal system is widely acclaimed as a combination of both unitary and federal features, no one has contested its strong unitary tendencies. One such unitary tendency is found in the form of veto power of the president vis-a-vis the state legislations. Article 200 empowers the governor of a state to reserve any state bill for the president's consideration. In the Hochest Pharmaceuticals versus State of Bihar case, it was held that the reservation of a bill is the discretionary power of the governor. Such reservation for the president's consideration is in fact compulsory when any law in question is concerned with the derogating from the powers of the High Court or acquisition of estates, taking over of management of any property in public interest, amalgamation of two or more corporations for proper management, as in Article 31A, imposition of a tax on water and electricity stored or generated from interstate river or river valley, that is Article 288(2). Even some of the bills pertaining to matters mentioned in the concurrent list may be reserved by the governor for the consideration of the president. This is in Article 254(2). The governor's action in sending a bill for president's consideration was held by several Supreme Court judgments as non-justiciable. For example, in the cases of Purushottam versus State of Kerala, 1962, Hochest Pharmaceuticals versus State of Bihar, 1983, and Bharat Seva Ashram versus State of Gujarat, 1987. Article 201 gives the options available with the president when a bill is reserved by a governor for his or her consideration. The president shall declare that he or she assents to the bill or that he or she withholds assent therefrom, or in the case of ordinary bills, may direct the governor to return the bill to the legislature for reconsideration. And now, what are ordinary bills? The bills other than money bills. The state legislature concerned must reconsider the bill within 6 months. If passed, the bill is once again presented to the president for assent. The president, however, is not obliged to give his assent even after reconsideration or repassage of the bill, and there is no time limit fixed for such assent. So, a pocket veto can be used by the president. In the case of money bills, the president may either declare or withhold his assent. There is no provision for sending it back for reconsideration in the case of money bills. Now, let's take a side note. The provision of unquestionable presidential veto power over the legislations of the federal units is not found in other federal constitutions, such as those of the USA and Australia. But yes, yeah, it is there in the Canadian Constitution. In Canadian Constitution, this power is comparatively higher, where the Governor General can directly disallow the provincial acts, even though not reserved by the governor concerned. In the Indian case, though the governor is an appointee of the president, the latter cannot directly disallow a state bill. Now, come to the misuse of the power. The provision for disallowance of state legislation has been misused by the union governments, especially with regard to those states ruled by parties different from that ruling at the center. The governors, who are virtually the nominees of the central governments, have reserved quite a large number of bills for the consideration of the president. Some of the bills so reserved were either rejected or kept pending by the president. For instance, the Industrial Relations Bill passed by the West Bengal Assembly in 1969 was put in cold storage till 1990. Some bills likely to have had beneficial effects were rejected. Some of the state bills which faced immature death were the Kerala Education Bill of 1959, Madhya Pradesh Panchayat Bill of 1960, the Haryana Legislators Medical Facility Bill of 1975, and the Kerala Land Reform Bill of 1980. The Rajamannar Committee appointed by Tamil Nadu and the West Bengal Government Memorandum on Center-State Relations recommended the deletion of both Article 200 and 201. However, the Sarkaria Commission report stressed the necessity of the articles but stipulated that whenever the President withholds assent to a bill, the reasons should be communicated to the state concerned, but this requires a constitutional amendment. The ARC, that is Administrative Reforms Commission, offered a different set of solutions. It observed that reservation of a large number of bills for the consideration of the president violates the federal spirit of the constitution. Only those state bills where there is a violation of fundamental rights or some unconstitutionality in policy, or where the legitimate interests of other states or citizens are involved, or where there is a clash with central laws, should be sent for the president's consideration. Irrespective of whether it is a central bill or a state bill, the veto power should be exercised by taking into consideration the merits of the bill. Veto should not be influenced by factors such as which individual or party or state is responsible for the bill. The basic rationale behind the veto power is to effectively check ill considered legislations, but this should not pose any threat to the smooth functioning of parliamentary democracy or the spirit of federalism. This is all for this video. In next part, that is fourth part, we'll discuss on ordinance making power of the President of India. Now a simple question for you. Which article defines the money bill? Do write your answer in the comment box. Thanks for watching the video.